Thanks for joining us. Today, we're continuing our series about the serious issues at the Board of Veterans' Appeals, and we want to highlight legal action CCK is taking to improve VA appeal delay. In this video, we'll be explaining one of two major initiatives our firm is taking.
First, let's discuss VA Regulation 38 CFR 4.16, total disability ratings for compensation based on unemployability of the individual, or TDIU. There are two ways a veteran may obtain TDIU. A veteran may be awarded schedular or extra schedular TDIU. Under 38 CFR 4.16a, a veteran must have one service-connected disability rated at least 60% disabling, or more than one service-connected disability with one condition rated at least 40% and a combined rating of at least 70% to meet the schedular requirements for TDIU. If a veteran does not meet these criteria, they can still qualify for extra schedular TDIU if their service-connected conditions prevent them from securing and following substantially gainful employment.
So 38 CFR section 4.16b states that a veteran's case should be referred to the Director of Compensation Service for extra schedular consideration when the veteran's service-connected conditions render them unable to work but do not meet the percentage requirements for schedular TDIU. So, how does this relate to appeals at the board? Many veterans seeking extra schedular TDIU in their BVA appeals find that the board refuses to issue a final decision on entitlement to extra schedular TDIU. Instead, the board remands these claims, meaning they send them back to the regional office for extra schedular consideration by the Director of Compensation Services. This practice is often futile because the Director of Compensation Services rubber stamp denies TDIU, and a veteran must appeal again to seek this benefit. And it means the veterans must wait even longer to receive a decision on TDIU.
The wait time can substantially increase because when an appeal is remanded for further development and the veteran is in the new system under the Appeals Modernization Act, the veteran loses their place on the board's docket. The docket is the veteran's place in line. By needlessly remanding appeals, the BVA is adding unnecessary development to the RO. Then, when back before the BVA, the veteran is placed at the back of the docket line.
So what are we going to do? CCK is taking legal action against the Department of Veterans Affairs. We are going to file a petition for writ of mandamus at the United States Court of Appeals for the Federal Circuit. A writ of mandamus is an order from a court directing a person or entity to perform or stop performing a certain action. Specifically, we are arguing that veterans have a legal right to waive a board remand for the regional office to correct a purely procedural defect that poses little to no likelihood of the regional office procuring new information or evidence to support the claim.
In other words, veterans should be able to waive their right to review by the Director of Compensation in favor of receiving a decision from the board that is more than qualified to make a TDIU determination. Veterans have a right to waive a remand under Section 20.802a for RO compliance with Section 4.16b.
CCK believes that the board is needlessly delaying appeals by not allowing veterans to waive the right to a remand in these cases. We believe that if there is no perceived benefit to the veteran when an appeal is remanded, they should have the right to forego a remand and get a final decision.
We will continue to provide updates as this legal action progresses. In the meantime, check out our recent videos to get a sense of the issues at the board and understand why we feel legal action is necessary. Thanks for tuning in.